Good evening. I'm Bill Fitzsimmons. I'm the Executive Director for the Canadian Centre for Men and Families here in Alberta. At CCMF Alberta, we provide programs that support men's mental wellness, such as individual counseling, men's peer support groups, and trauma recovery programs. We also provide programs around parenting and Fueling Fathers program that's presented monthly. In addition, we have this legal program. We have webinars every 4 weeks with Charles Fair, and we also provide consultations with Charles in individual initial consultations. So welcome to our webinar tonight. It's a beautiful evening, so we appreciate you taking the time to join us. I'd like to introduce Charles. Charles um, is a fully qualified lawyer, and I've lost his intro information, but I'll get it back here. So Charles, I just want to acknowledge Charles for the amount of time and effort that he has put into our legal program, presenting over the last few years webinars on a monthly basis, as well as providing legal consultations to our clients. Really appreciated. Without Charles' effort, we would not have this successful program, and it represents a huge donation of time, and anyone that's had a lawyer engaged knows the value of that time that Charles is donating to this program. Charles is obviously a fully qualified lawyer. He graduated from the University of Toronto back in 1990. Has been a litigation lawyer for most of his career, representing clients at all levels of court in Ontario and Alberta. The team at Fair Legal are your champions for justice when life gets messy. And as I say, Charles has been involved in, as he describes it, messy, high-stakes civil, family, and criminal legal problems. So without further ado, I'd like to invite Charles to begin the session tonight. Thank you, Charles.
Great. Thank you, Bill. It's always a pleasure working with CCMF. I really value what the contribution you guys make, because I think providing services to men going through the breakup of intimate relationships is really important. I'm just going to share my screen tonight for tonight's topic here. Let me just make sure I've got that right. And just so you know, we're going to go through a number of points here on, we've entitled it Family Law 101, What You Need to Know, primarily about divorce. We'll be touching on those situations where people are not legally married, but tonight we'll focus on the divorce, those who are legally married and needing a divorce. There is an opportunity to ask questions. What I'd like you to do is post your questions either to Catherine Sekeli-Stevens, who's assisting us with this webinar tonight, or there might be a question spot on this, I'm not sure. In any event, you post a question, we'll be able to address that at the end, and Catherine will assist with moderating those questions. So I just wanted to also say that this is a really big overview of some of the common steps, and because a lot of people don't go into a divorce knowing what they need to know, and you shouldn't have to go to law school to figure all that out. And I'm going to give you a very big bird's eye view of some really basic core steps that are involved in getting a divorce here in Alberta. The general rules are applicable across the country, and I'd caution you to not try to get advice from the internet or from the US and or British programming. The internet, I suppose I should qualify that, because this is going to be published on the internet, this webinar. But again, this is not a substitute for getting good legal advice, as we'll discuss further along. There are a lot of variables to divorce. Every family is different. You've got with or without kids. There are blended families, mixed marriages. There are people who are living together or without being married. There are those who are married. There are same-sex marriages. There are marriages without very many assets, and then there's marriages or relationships with a lot of assets, with businesses, self-employment income. There's people having pets and all sorts of things that make every family different. And the reasons for the breakup are as varied as there are marriages. I think they're the reasons why you get down this path may not be the same. But in the end, a lot of the things are very a lot of the steps are very common, and so we're going to look at those first 10 common steps to the Canadian divorce process. So I'm going to start off with the first one, which is let me just see whether I can do this right here. There we go. Okay, so first is consider counseling or mediation. I know this seems to be an odd way to start, but the Divorce Act itself talks about that every lawyer has a duty to explain to clients or those who are wanting to initiate a divorce what the provisions are in the Divorce Act that are intended to encourage or support the reconciliation of spouses. And so counseling is obviously one way to do that. And so there's a mandatory requirement to at least consider counseling as a way to reconcile. And of course, that's if counseling is appropriate, because sometimes in some breakups, it's not appropriate to try to put people in the same room to try to reconcile. Some of the differences may truly be unreconcilable. Mediation is also a theme that's going to run throughout all of the legal processes, is because if there's a way to resolve your disputes through some kind of mediation process, the courts are going to prefer that, and you're going to typically get a better result. So some people do start the mediation process right off the bat, and that might work. And there's some pros and cons to starting with the mediation. Sometimes mediation only becomes viable later on, once folks have kind of gotten sick and tired of litigating, as we'll see. But mediation is an option, and a lot of couples do say, look, let's try mediation. Maybe they can reconcile through that process. Maybe they can at least preserve some of the relationship and save some legal fees along the way. Now, the next step is oops, where do we go here? Sorry. Gathering financial information and records. This one is a little bit of a head scratcher for some people, because early on in the process, when you go to see a lawyer, or even if you're representing yourself, you're asked to gather a lot of financial information and records. Some of the records are kind of obvious, like if you want to get a divorce, well, let's make sure you're actually legally married. Let's look at the marriage certificate, and you will need that. Another common document that is required is a photograph of your spouse, and that will become important down the road. But then the other ones, the financial information, is a bit of a head scratcher, as I said, because you go to see a divorce lawyer or family law lawyer because you have a breakup with your a relationship breakup. What does that have to do with money and financial information? Well, the financial circumstances of the marriage is a big part of any divorce. And so it's important to get that information gathered early on if possible. That's information about income, your own income, and if you know information about your spouse's income, that can be helpful. What your assets are, that is the property that you own, whether that's vehicles or houses or cottages or um, investments, RRSPs, that sort of thing. And then the other and it's important to gather that information because it is required, and the easier you can make it for your lawyer or yourself this down the road, that's going to be better. So it's important to gather that information as completely as possible. There are guidelines for the information that must be shared, and you can find that information on the court's website. Typically in Alberta, it's albertacourts.ca. You click on the family law section, and there will be links to basically a checklist of information that must be disclosed to the other side and what you can expect to get from the other side. And really what the goal is to make sure, number one, that the separation of the married couple is fair and reasonable. We're trying to get to the right result, and we got to know what the information is, because without the basic core information, it's very difficult to make sure to be satisfied that what you got is a good result. The next thing you want to do is you want to consult a lawyer. I think this is an important step. Obviously, I'm a lawyer, but one of the things that you want to do early on is make some decisions about what the next step is. We're going to be talking about some really core basic steps, but there might be a need in your particular circumstances to choose a slightly different path, and a lawyer can talk to you about that. A lawyer can give you some detailed advice about how the courts or the judges are going to view your particular situation. What are the pros and cons of any particular step that can be taken? This will ensure that your rights are protected. This will ensure that or help you ensure your rights are protected, and also ensure, especially if you've got children, that your rights as a parent are protected. Now, the next step, typically, if you're going to start and ask the courts for to get you divorced, is you file a statement of claim for divorce, and this is the document that really sets out what it is that you're wanting. You want a divorce, you want to be separated from this individual, you want the right to remarry, so that's a divorce. Then you want to have property division in there. You want to deal with any children, what the parenting rights and responsibilities are, and your financial responsibilities to each other. And then there's other things like who gets to keep what, or who gets to live in the matrimonial home, for example. Now, the statement of claim for divorce doesn't actually give you a court date. All it does is essentially give you a court file number and give you a way to take further steps that you can ask the court for assistance in sorting out your situation. The next step is you need to serve the statement of claim for divorce. And this is important because our system is really dependent on making sure that if you're going to ask the court to assist with a decision, the court wants to make sure that both sides are given an opportunity to say their side of the story. And so you can try to do this without letting the other person know what it is that you're doing, and you're going to get into court, and the first question the court is going to have, if the other person isn't there, is, okay, Did you serve the documents on them? Did you serve the statement of claim for divorce? I'm going to say if you're not legally married, you wouldn't be filing or serving a statement of claim for divorce. You would be serving a family law application, or you may be filing, in some cases, a statement of claim for division of matrimonial property. It's a little different process, but again, that's something that you will need to get some additional research and do some additional research on. Now, the next step after the statement of claim for divorce is filed with the court and it's been served on on your spouse, is you you now wait for it, a statement of defense. And again, this is in divorce action, sometimes this step gets delayed quite considerably, essentially depending on where the spouse is. You can have only 20 days to respond, 30 days or 60 days. And that is for if you have that's the time that the spouse has to file a statement of defense to the filing the statement of claim for divorce, which is, like I said before, the goal is make sure both sides have an opportunity to say their particular their side of the story. And that's what the statement of defense does. It says, okay, here's what they why we agree or disagree with what is in the statement of claim for divorce. And you can also file a counterclaim, which is you don't agree with what the other side wants, and you get to say, well, I want something different, and you put your claim in a counterclaim, and it's the same basic list: the divorce, the division of property, dealing with rights and responsibilities regarding children and parenting time, and financial support of children and spouses is all part of that counterclaim for divorce. Now, again, we've talked about the negotiation is a common theme throughout this process. If you can negotiate a settlement, you are going to get typically a better result across the board than if you have to go to court. And that is especially true when it comes to dealing with children, because nobody knows your children like the parents do. Now, settlement is not always possible, and you have to go to court. And typically, in a divorce proceeding, this is where you're applying for what we call interim relief. It's you got to sort something out about the parenting, because otherwise one parent isn't going to see their kids, and so you got to set some rules. And so you can't get an agreement. Mediation hasn't worked, or somebody doesn't want to do mediation. Nobody wants to talk. They can't even talk to each other civilly. It all breaks down. Well, then let's get to court. Let's go to court. Let's bring an application. And those court applications, again, that's if negotiation is unsuccessful, then you go to court. And now it's the same process, but a kind of a mini process now. The court application is saying, okay, court, I want time with my kids. I want to have primary decision making of my children. I want to have my children all of the time, and just have the spouse have a little bit of time with the children. I would like to get interim support flowing for the children, or for the spouse, or for myself. And that is, those are typical applications to the court. Other applications are possible, things like applications for restraining orders and emergency protection orders, orders for exclusive possession of the matrimony home, orders to sort out certain aspects of property, like let's get a vehicle transferred, the other side isn't being cooperative, and you can run off to court to get the court to sort out a lot of these things. You have to be very careful about running off to court about every little thing, because eventually the court is going to say, oh, know what, this is too much. You can't keep coming here for these temporary orders. You gotta move on with the case and move the case and get down and set it down for a trial. And that's so the court applications are useful to get some interim orders. And what the courts try to do is try to make a fairly, they want to get as close as they can to what a good result is. Because quite frankly, if there's an order that it ends up people are happy with or satisfied with, then they just kind of live with it. And then eventually the divorce ends up getting finalized without a lot more effort, and you don't need to go to a trial. Now, part of that process, and this is again something that I'm going to set out here, the finalizing the interim court orders. This is a bit of a process. I've added it in here as an additional step because it has to be done after the court makes an order. You got to get it properly documented and filed with the court. And sometimes there can be disputes over how these orders get worded. And the basic idea here is that the order has to reflect what the judge actually said in court. The order takes effect as of the date the judge opened his or her mouth and said what it is that's going to happen. That's when the order takes effect. But sometimes it takes a while to figure out what the best way to put that in writing is. And there's a bit of back and forth. And sometimes eventually somebody has to go to court to say, Judge, we weren't quite sure exactly how to word this. Can you help us out here and decide how this order should be worded? And then the judge signs it. The order gets filed with the court, and then it gets served on everybody who's got an interest or has to follow the court order. So as you can appreciate, this is where a lot of the work in a divorce is in these interim court applications. So I'll just go back a step here. These negotiate a settlement or go to court applications, finalizing the interim court orders. And the goal in all of this process is really, can we get the spouses to line up with a satisfactory resolution, that either by agreement or by court order, and then we say, okay, we're all done now. We can now get the very last stage. Typically, is an application for a divorce, and if everybody's in agreement, you can do just simply submit the paperwork over the counter at the courthouse, and that's what we call a desk divorce, because everything has to be agreed on or already resolved by the court, whether through these interim court applications or through a trial. Notice, by the way, that I didn't include trial as a common step, because most cases, something like 90% or more of cases, settle or are resolved without going to court. So trials are actually quite rare. They add a great deal of delay and expense to your case, even more than the interim court applications do. So, but I haven't included it as a step because, quite frankly, it's not that common. In any event, if there are any children, then that the court cannot grant a divorce unless the children the parties have figured out what's going to happen with the children. And so if you've sorted out whether the parenting is going to be shared, or one person is going to be the primary parent and the other is going to have what we used to call access rights, you sorted that, or parenting time is the current term, of course. Once you've sorted all those issues out, and in particular what the child support arrangements are, then you can get your divorce. Now, as I say, that application is then just submitted over the counter, and the court clerks check all the boxes, and if everything's fine, 2 or 3 months later, you'll get your divorce, and the court will give you a certificate of divorce, and the divorce is effective 30 days after the judge signs it, the actual divorce judgment. Now, if you need to get a divorce earlier than that and everything else isn't resolved, if you need to get a quick divorce because there's a remarriage happening, and there's very, very specific conditions that can apply here, then you can say to the court, I would like to get a desk divorce, even though we haven't solved everything else. And so, yeah, that's another one of those court applications where you have to apply to court, or get the consent or the agreement of the other side to say, okay, we haven't quite agreed on everything, but let's just sever the divorce. Let's separate the divorce itself from the rest of the proceedings, and then we can get the divorce underway. And sometimes that actually helps the case, because it's actually easier for people to feel to come to a resolution when they realize, this marriage really is over. I really am divorced. I can remarry. My spouse can remarry, and we can move on with our lives. So that can sometimes help focus everybody's attention on getting the rest of their case resolved. So that is the final step, of course, is everything is tied up. You've sorted out all of the various aspects of your breakup, whether that's a division of property or support issues or parenting issues. Sorted that all out, and now you're legally divorced. And that's the whole process in a nutshell. So, next question is whether you have any questions for me.
There's one question, Charles, but I think we'll defer it to the end because it's not specific to this topic.
Oh, okay.
Charles, I've got a couple here, and just pulling this up. So how does it complicate when there is a child on the way but not quite born?
Well, that child on the way is going to be just like any other child. It is likely going to be a child of the marriage. Of course, there can be some complications if the suspicion is that the child is not a child of this marriage, but the child of another relationship. There are provisions for going to court to get paternity testing done and that sort of thing. But when it comes to children, the courts are going to be very focused on making sure that children are looked after. Now, as to whether there's some precise rules about children on the way, I would have to check the specifics of it. It's actually been quite some time that I've encountered that. I do as typically as part of my intake, I ask clients whether anybody is expecting a baby, because that can well, it just adds one more party, so to speak. So that is a question, and it hasn't happened in my practice for quite a while for some reason. So yeah, there we go.
There's another, but it's very long, and I'll summarize it.
Okay.
There were assets on both sides before the marriage. There were gifts from one parent specific to their child. There were gifts to the grandchildren, and there were gifts to each other. So who owns all those assets, and how does it get dispersed?
Okay. So the basic rule is we start with the basic propositions that whoever owns the asset owns the asset. If it was acquired during the course of the relationship, so that includes the time before the marriage, if people were living together, then anything that's acquired between or after that, or sorry, anything that's acquired during the marriage is then divided, and the presumption is that it's going to be divided equally. Now, when you think about it, there's certain assets that don't divide very well. Like, how do you divide a car? Because if you actually take a chainsaw to it, or a saw to it, what do you call them? Those, whatever. Yeah, if you cut it in half, nobody can use it. So essentially, what the process involves is getting out a spreadsheet, listing the assets that everybody owns, and then there can be either a valuation of each particular item of property, and then you come up with an equalization payment, or you start horse trading and saying, okay, well, if you take the investment account, then I get to keep the house, or vice versa. So pensions are another asset that can be divided, and that one can be divided through a pension division order, or somebody can say, look, you keep the pension, or I'll keep the pension in exchange for some other consideration somewhere else. It can be a fairly complicated process because different assets have different tax consequences, and those tax consequences should be taken into account when doing the property division. Now, that's the basic principle, and the principle is that the assets are divided as of the date of trial. So if there's any increase in value in a property during the course of the marriage, then it's that increase in value right up to the date of trial or the final resolution. That's what gets divided. Now, what you've described is a process or a fairly common situation, or at least different parts of it are common. It might not be common that it's all together, but the same basic principles apply. The only property that gets divided is property that's acquired as during the marriage as marital property or as family property. If the property was acquired before the marriage, then it's exempt. If it was acquired as a gift during the marriage, then it's exempt and doesn't get divided. If it was a gift from one spouse to the other, then it's a gift and it doesn't get divided. If it's a gift to the children, it doesn't form part of the matrimonial property or the family property. So that's a basic thumbnail rule, and sometimes it takes a little bit of figuring out where things are when you're doing the spreadsheet, you've got to actually add another few rows for those properties that are exempt. Now, unfortunately, it can get even more complicated after that, because they if you and I had one case where both parents received inheritance, oh sorry, both parties received inheritances from their families. So when the husband received his inheritance, that money went to buy some stuff for the family. It went to pay for a vacation. It paid off some debt. And I think maybe they bought an RV or something, but most of it went into just general family expenses. When the wife received her inheritance, she put it into a separate investment account. And when the parties separated, her inheritance was exempt from division, but his inheritance was not exempt from division because they had spent it. Similarly, if there can be other situations where the parents will give money to the couple, or they will give money to one of the spouses, and if the parents give money to or assets to the two parties, like quite often they say, here's some money, you can buy a home, and the home is put into joint names. Unless somebody's documented it differently, that's going to be a gift to both parties. And if it's a gift to both parties, well, it just formed part of their property, and while it might be exempt, if it's an equal gift, it doesn't really make any difference when you're doing your spreadsheet analysis at the end of the day. So that's property division in a very tiny nutshell. There can be complications in all sorts of ways, particularly if there's business interests that have to be valued, or if there's difficulties in valuing the assets. And sometimes the court just has to step in and say, all right, you can't agree on what the value is, we'll sell it. See what happens then, right? Then you have a value because somebody's paid money for it.
Thanks, Charles. We have several questions in the Q&A. The first one is, for a quick divorce, the child arrangements and support need to be agreed upon. Is that correct?
Yes, because the judges cannot grant the divorce. They can't sign the divorce if there's children. The children's needs aren't looked after. Now, sometimes you can get around that if you can satisfy the court that processes are in place to deal with it. I don't like when I've seen that, I think it's the wrong way to do it. I think you have to, unless there's some really good reason why you need a divorce, you've got to take that extra step to make sure that the children are looked after. Because what can happen is, yeah, you get the divorce, and then people stop actually dealing with the children, and the children have to be cared for.
Yeah, and the second part of that question was spousal support, and does that need to be agreed upon as well?
Spousal support does not need to be agreed upon. It's much more difficult than child support to figure out. There aren't as many fixed rules as there are for child support. It does not need to be agreed on as part of the divorce. There isn't the same bar, but again, it does create issues if it's not resolved properly when the divorce is in place. So you need to, in that case, sever the divorce and get a specific order that the divorce is being severed from the spousal support. We call that the spousal support in that case, we call it corollary relief. This is so you get an order, you apply to the court for an order severing the corollary relief. The parties can get separated or divorced, and then they're already separated, sorry. And then so they get divorced, and the spousal support can then be sorted out through the court process separately. The courts can grant that because, quite frankly, they don't have the same interest in making sure the kids are looked after.
The next question, this individual has a separation agreement with his spouse or ex-spouse, now planning to apply for a desk divorce. His ex-spouse doesn't want to proceed to divorce, wants to stay in a separation status and not to proceed with a divorce. He wants to proceed with a divorce, and he's asking what his legal rights are here.
Okay, so as long as the children are looked after and there's a separation agreement dealing with everything else, he can apply to the court for an order dispensing with his spouse's consent. The desk divorce, I should have mentioned that earlier, it does have to be on consent, but if you can't get consent for some reason and the other spouse is unreasonably withholding consent, then the court will order that the consent be dispensed with. It's basically just an opportunity for the court to make sure that everything's being done on the up and up before they just allow the divorce to go through.
Okay.
Because you'd have to apply, again, basic core principle throughout. Got to give the other side notice. Say, so the spouse is not consenting. You say, okay, I'm going to court. Here's the date. Show up in court and say why you're not consenting. And if you don't have a reasonable excuse, well, maybe the court will order you to pay the costs of that. I mean, that's one way to deal with it.
Okay, we have a couple of questions around parenting arrangements. So the first one is this individual is asking how he can move forward when the other party is closed to communication, particularly around parenting. In this example, a parent with whom the kids are living is not allowing the other parent to have parenting time and has blocked phone, text, and email.
Yeah, tough. That's when you make an application to court to get the relief you want. And it's so important in this case to get legal advice, even if it's just a consultation to give you some guidance on how to take the next step. Especially in that situation, you need to get legal advice on how to do it. The courts will intervene. The courts have to make an order that's in the best interest of the children. They've got to give the other side an opportunity to say their side of it. And so it's hard to say in this kind of forum what exactly the approach to take is, because there's different kinds of ways of doing it. And I've had some situations where we've been able to get the parenting. And one where the mother had completely cut off contact. The dad, who was my client, was dealing with the mom's new boyfriend. So you can think that's kind of a volatile situation, and he was getting quite frustrated. He called me up and said, "What do I do? Because I'm afraid this thing is going to get out of hand seriously." And I stepped him through, well, here's some tips on how to communicate with your ex's new boyfriend. You can kind of guess that's a bit of a volatile situation. But I think he was able to take that advice and reach out to his the boyfriend, who then essentially helped him to open those lines of communication and got the parenting going again. And he was so successful that she dropped her application for spousal support, or child support rather. So much for having that file. So, but the point is that it just, the point is to get to resolution, and sometimes there's ways of doing it that can be successful outside the court process. Sometimes the court process is very necessary. In some situations, there may be grounds to get children's services involved or child welfare involved. You really do need to get advice on how to proceed.
related to that, there's another question. What happens if the mother wants to put limitations and supervision, even though it's not necessarily needed, but she has her own reasons for doing that?
Yeah. Yeah, well, she's got to give her reasons to the court. The court doesn't like supervised visitation for a long time. So you will often see supervised visits for short term while everybody calms down. And then if everything's going well, then the court's going to say, because really, is it really in a child's best interest to spend time with a parent with a supervisor present? Not really. So they the courts will push the parties to move to an unsupervised regime. And now in that process, what might make sense is you get it supervised by professional supervisors who can produce reports, and it becomes a lot harder to for the mom to resist parenting time for dad when the supervisors are saying this is great, dad is doing really well with the kids are responding well to him, he's attentive to their needs, they're enjoying their time with their dad. Then she's really got to do some explaining in court as to why the supervision needs to continue. So again, it's very important to get legal advice for that in that situation.
Thank you. Next question is a quick one around possessions. Can your ex demand a percentage of your CPP or old age security or other government pensions as part of the settlement?
The old age security, they are not entitled to. What they're entitled to is a division of pension credits unless you agree or there's a court order otherwise. But the federal law, so the CPP, that's the Canada Pension Plan, the federal law says these pension credits are divisible. And however, it is possible to agree or potentially get a court order to not divide those credits. It creates a problem in my mind. So I tend to recommend that people just divvy up those credits, because I think there's a problem with valuing CPP benefits in particular. And so it's much simpler to just simply divide them, which means he gets half of hers and she gets half of his, and that has the effect of equalizing their CPP benefits. So now it's unfortunately, it's a little, it may not be as fair if one party has very few CPP credits. So that's when you might have an order or an agreement that those are not divided. But that I think would be kind of an exception. And I say that's just my preference. And again, this is not legal advice. You have to get legal advice on the individual circumstances of your case.
Now, Charles, we still have probably 4 or 5 questions in the
Okay.
Q&A. So I don't know whether you want to extend a little bit to answer those, or how you'd like to handle that.
Well, I can try to shorten some answers as well. And the other thing is, I want to remind people that if you contact CCMF, I don't actually know what the process is, Bill, but what I do is I get referrals from CCMF for an initial consultation, and I provide that service for free. But you got to go through CCMF to do that, because if you don't go through CCMF, you're going to go through my regular system, and I charge for those consultations, because my view of it is you get a consultation from me, you're going to leave with something that's very valuable, and you can take some steps at least to make your life better based on the advice, even if limited, during a consultation. So I think there's good value there, and I try to do the same thing for the CCMF clients. through that process. So that's
Yeah, just